Hi everyone, this is attorney Rob Wells here, and in this video we're going to be talking about AB 3088 and other state of emergency regulations that are affecting tenancies. So welcome to our presentation on AB 3088 and other regulations and orders affecting tenancies here. I know there's going to probably be a lot of information in these videos that will be coming up. There was a lot of changes that happened within the past week with California's emergency legislation represented in AB 3088, and then we'll also be talking about the CDC's emergency eviction moratorium and how these new regulations affect tenancies within Solano County and so forth with the other existing emergency ordinances that are going into effect. Okay, so for the legal, lease, and disclaimers, I have to tell you all this information now. Basically, I'm making this as an educational video. Don't take this as legal advice. You really need to sit down with legal counsel of your choosing to figure out your own individual situation. These are very factually driven issues now with landlord-tenant legal advice and doing evictions. What once used to be a very simple process has now been they've made it very complex. So you're going to need to get a legal opinion on your own very specific situation. Also, I just want to address that this video is primarily for Solano County evictions and landlord-tenant relationships because, as you may be aware, different cities and counties have their own ordinances and so forth that also may play into effect. Also, if you're in a rent-controlled jurisdiction like San Francisco or Oakland and so forth, they have their own special rules that may apply. We're trying to make this information as accurate and up to date as possible, and as of September 5th, 2020 of the filming of this video, this information is accurate. However, in the landlord-tenant space over the last 6 months, it has changed dramatically. Even day by day, we've seen changes here. So if you're watching this video in the future, just be aware that the information may be outdated. We'll try to get you updates as best as possible here, and the video may be considered legal advertising or an advertisement. So we're just letting you know right here, right now. So like I said earlier, the landlord-tenant space has changed dramatically in 2020, particularly over the last 6 months due to the COVID-19 situation. When I started practicing in 2013, these landlord-tenant issues were pretty straightforward in most cases. With all the changes in the landlord-tenant space right now, it has been really complex. It's even hard for me to try to keep up with what's going on and so forth. Hence, this video coming to you almost a week after the legislation has passed. I just hadn't really had time to really keep up with everything that has been changing. The legislature had to wheel and deal to actually get this emergency legislation out there to the public before the eviction moratorium at the state level for the state courts expired. This video is not going to be designed to be an all-inclusive video about every regulation that you have to watch out for. It's a big overview. It's a lot to digest. I'm trying to break it down in simple parts so y'all can understand, because you could write a whole legal treatise about all the changes that have been made. And before we start off, I want to just have a little bit of humor for you here. So I got a couple of videos for you to watch. Okay, now I know a lot of you probably think that it's the public's perception that landlords are just these billionaires that have all kinds of money and so forth. And I know we've been getting beat up in the landlord-tenant space for quite a long time here. And I think the legislature and everyone else in government probably thinks landlords are somewhat like Scrooge McDuck. Let's play the cue here, the clip here. I always love this scene. I think that's what's probably going through the minds of the legislature is every landlord is just playing with money, just throwing it up in the air. We'll stop that here. But in reality, I'll bring us back to reality here. This is probably what most landlords are probably going through right now. Let's cue the family law clip here. This is probably what most landlords are going through right now. I'm sorry. Just a little bit of side humor.
Okay, so let's begin to talk about the new regulations that are going to be affecting Solano County tenancies. The biggest two items that have come since last week have been the Centers of Disease Control CDC Order number 2020-19653, which was published on Friday, September the 4th, and also California AB Bill 3088, the Tenant and Homeowner and Small Landlord Relief and Stabilization Act, passed on August 31st. And these have been some major changes in the landlord-tenant space. We'll start with the CDC order. So this CDC order was published in the Federal Register on September 4th of 2020. This is Friday. What did the order actually do? It bars the landlord, owner of residential property, or other person with a legal right to pursue an eviction or possessory action if certain conditions are met. In other words, in California, you can't pursue an eviction from September 4th until at least December 31st, 2020, if certain conditions are met. Note in the order, it mentions person, but it's asterisked in the order that includes any business entity or organization, i.e. your corporations, LLCs, partnerships, associations, etc. So what are the conditions needed to trigger this protection? Well, one, the tenant, leasee, or resident of residential property needs to provide their landlord or owner or whoever is going to try to evict them a form declaration under penalty of perjury stating the following items. Predominantly, they've tried their best efforts to obtain government assistance for rent or housing. They either make, as a single individual, $99,000, or they anticipate making less than $99,000, or no more than $198,000 if they're filing, a married joint tax return. And they're unable to pay the full rent or make a full housing payment due to a substantial loss of household income. The individual is using their best efforts to timely make partial payments as close as they can to the full amount of rent which would be due, and the eviction would likely render that individual homeless or force them to move into close quarters with some other individuals here. So basically, in other words, there's a model declaration in the CDC order. But if the tenant basically just gives you a declaration saying, hey, I'm going to have a hardship and I don't make more than $98,000 a year or $198,000 a year, you're not going to be able to evict them, basically. You get this declaration, that's it, landlord. You're done until December 31st of 2020, absent any rescission of the CDC order or any extension and so forth. So what are the expressed eviction exclusions under this order? Well, per the order's own terms, nothing in the order precludes evictions based on the following. Tenants engaged in criminal activity while on the premises, they're threatening the health or safety of other residents, there's damage or posing an imminent or significant risk of damage to the property, you're violating any applicable building code, health ordinance, or similar regulation relating to health or safety, or violating any contractual obligation other than timely paying of rent or similar housing related payment. That includes non-payment of late fees, penalties, interest. I would also probably interject if your tenant's required to pay like utilities, like garbage, since it involves similar housing related payment. I would construe that as, yeah, you can't go after them for not paying the garbage bill or something like that. The order is not applicable to any state or local or territorial or tribal area within the moratorium on residential evictions that provides the same or greater level of public health protection that are listed in the order. I'll get into my King George III moment with this order and momentarily. I think with most of the eviction ordinances and statutes on file right now, CDC's order would probably prevail over most, and I'll get into that momentarily here. The order also doesn't preclude any state, local, or territorial or tribal authorities from imposing additional requirements that are greater than the public protections outlined in the CDC's order. And additionally, the order does not apply to America Samoa, which has reported no cases of COVID-19 until such time they get cases. So, yeah, America Samoa, you're good for you. So, question. Does this order apply in Solano County? We have AB 3088, the county emergency ordinance. Don't these control? Well, like I mentioned in the other slide, I think the devil's going to be in the details about what is more protection under the CDC's order versus AB 3088 or Solano County's emergency ordinance here. Let me tell you the reason why. So, under the CDC's order, there are criminal penalties contained in the CDC's order. Again, because once the tenant provides you this declaration, they are protected under this order here. Let me show you. And it's under 18 USC 3559 and a bunch of other USC statutes and Code of Federal Regulations. Orders provides for a fine of at least $100,000 if the violation does not result in the death of a person or 1 year in jail, or both. Or if it's an organization that does it, versus a person, you're subject to a $250,000 fine and going to jail here. That is a pretty significant penalty here for violating one of these CDC's orders. It's kind of weird that the Centers of Disease Control is coming up with their own order versus having a some type of legislation come out from Congress. Well, I'll be devil's advocate here. Everyone knows that it's going to probably be pretty hard to get some type of legislation through Congress right now, just the way everyone's acting. So they're kind of relying on these agency regulatory orders like CDC is doing. I've been joking with some people, what's next? Am I going to get an order from NASA telling me, hey, you can't do an eviction because you're affecting the pool of applicants for the newly created Space Force? I don't know. This to me is going beyond belief here, because in most county and state ordinances, at least in California, to my knowledge, there is no criminal penalty. There might be civil fines, or you may, your eviction may be declared null and void, but there's nothing on the level of what the CDC order is saying, is the penalty here. Criminal, like you can go to jail type criminal. And that's kind of why I'm saying, we're kind of having a little King George III moment, 1776 type situation here, because these folks are starting to, in my opinion, it's starting to get a little tyrannical here with, I know it's a state of emergency. I understand that, this is an unprecedented situation, but I think you got to remember too, all these statutes and laws and ordinances and orders have to comply with the Constitution, and I see a few problems with this, but that's for a different topic, a different day here. That's just my 50 cents. I'm sorry I went on my soapbox here, but I think playing devil's advocate, my point is this CDC order probably has more stringent protections based on this criminal penalties in it versus any type of legislation we've seen like in AB 3088 or any type of county ordinance, because there's just no criminal penalty for that. So, word of caution, if you do get a declaration from your tenant, declaring that they're going to have a hardship under CDC's order, I would tread very lightly. I would not proceed with your case without legal counsel taking a look at all the situation, your situation, kind of analyzing it, because this is going to be a highly factual type of situation, whether or not this order applies to you or not. That being said, I'm going to move forward from here. So, next on our list here, we're going to talk about California's AB 3088. This package was passed in response to the Judicial Council of California, and for all those that don't know what the Judicial Council of California is, it is the administrative body that governs all 58 county superior courts in California. So, a little background for those that haven't watched my other videos here. Back in April of 2020, the Judicial Council passed several emergency court rules here, one of which basically barred virtually almost all evictions during the time of the state of emergency, as COVID-19, the shutdowns and so forth for COVID-19 were coming along. The governor in California, Gavin Newsom, basically gave certain agencies, including the court judiciary, emergency powers, basically, to create emergency rules and so forth to respond to the COVID-19 crisis. And in response to that, the Judicial Council passed a ban on evictions for a certain period of time. Well, until at least the state of emergency was declared over. Well, we've been in the state of emergency now for coming on 7 months now. So the Judicial Council figured that since the California State Legislature was back in session, they could pass some type of emergency legislation, and they didn't need this new their court eviction bar. So that's hence you got AB 3088, which was probably passed within it was like a 14-day period that the legislature had to basically act immediately, because this court bar, the Judicial Council's court bar, was going to expire September 1st. And I think the Judicial Council announced that probably like August 13th or 14th, somewhere in that time frame. So hence the legislature went into overdrive and passed this legislation here. It basically consists of a dozen changes and additions, additional new statutes. Many eviction-related statutes were amended, including the recently passed AB 1482 package, which consisted of Civil Code 1946.2, 1947.12, and 1947.13. And the biggest one, at least in our business here, is Code of Civil Procedure 1161, basically, which is the California's eviction statute. That's where we get the ability, a landlord has the ability to evict a tenant, and, it lists the number of reasons where tenants can be evicted. Non-payment of rent, fulfill an obligation of the lease agreement, expired lease, and so forth. So my presentation here is going to focus on residential evictions for single-family homes, your condos, and your multifamily properties. There are also protections were made for mobile homes, which function a little bit differently. They don't use 1161. for the basis of an eviction. And I'm talking about mobile home, like in the sense of, hey, you have a trailer and you park it on a lot, with utilities and so forth. I'm not talking about if you rented out a mobile home to a tenant. That's covered. That is not going to be covered in this presentation here. Now, we will also be making additional videos for protections for homeowners that were affected by AB 3088. There is a foreclosure bar, basically, for single-family residences, 1 to 4 units in here. And there's also been changes to small claims court to allow landlords to collect more money inside a small claims case. We're going to have to get to those in a different video because this video alone is going to be long enough as it is. And it is going to be quite confusing. At least it was confusing to me. However, I don't know if you've heard me say this before in videos. I was like the C- student and everything. It takes me a long time to understand these things. And if my understanding does change based on more information, you bet we're going to send you more updates and so forth on that. But this was kind of a hard bill to digest. It was like about 36 pages long here. So I'm going to try to do it as best I can in here. So the biggest change in the eviction statute was for non-payment of rent and defaults based on paying money. Your notices of pay, notices to perform. You didn't pay your garbage bill. You didn't pay your PG&E bill, etc. You didn't pay late fees and so forth. All cases dealing with money or rent are subject to this Tenants Protection Act 2020 until at least 2025. I believe it says in the statute February 1st, 2025. Don't quote me on that, but I know it is in effect until 2025 right now. So the first thing I'm going to talk about, and I'm kind of, I didn't break up the presentation in order of the statutes listed in AB 3088. Instead, what I did was I kind of methodically put it together where, hey, there were a couple of eviction bars based on certain dates, and then we'll talk about the new quote-unquote 3-day notice to pay rent or to perform covenants. Those have become 15-day notices, but I will refer to them as 3-day notices because everyone in the business kind of refers to a non-payment of rent notice to a 3-day notice. So we'll clarify that. That's kind of the fun news right here is some of these termination notices have been extended and have new requirements here. But I'm going to start out with CCP 1179.1. It's a new statute added to the eviction list of eviction statutes here. It basically has a restriction on that there shall be no evictions based on non-payment of rent or other charges until at least October 5th of 2020. Courts are prohibited from issuing any type of eviction summons or entering any type of default or default judgment on any case that involves non-payment of rent and or paying of other monetary charges. The statute relates to any action that is in whole and part on non-payment of rent or charges, meaning if you have multiple causes of action, in English that means other legal reasons for a court to enter your eviction judgment. Let's say you had a eviction case that was based on non-payment of rent and then your tenant also didn't pay their garbage bill. Those are actually two legal reasons to evict a tenant, or that you would have two legal causes of action in legalese here. The court is basically saying that the court is barred from taking any type of action on your eviction case until at least October 5th, 2020. So absent, any other ordinance that would, stop an eviction. Solano County has their own eviction moratorium already. So this kind of doesn't really change anything, at least out here in Solano County. But you should just know that the court statewide can't do anything until at least October 5th, 2020. Next new section is 1179.03.5. Courts cannot enter eviction judgments or cannot find a tenant guilty of unlawful detainer in legalese before at least February 1st, 2020. Now, what this means in English is the court is further restricted by this new Code of Civil Procedure section that they can't do any type of eviction that is not in this list of reasons why you can evict a tenant until at least February 1st of 2021. We'll just go through the common scenario. So if you had a case that where the cause of action or the reason that you were evicting them, if that accrued before March 1st of 2020, let's say I had a case that dealt with, hey, the eviction notice expired in 2019. Well, in that case, the court can move forward because it happened before March 1st, 2020. It's based on your termination notice. So absent non-payment of rent, that's I know some of you landlords are going to be savvy. I had a notice I issued back in February and I couldn't prosecute it because of the eviction bar. Well, this covers you, but for other cases you might be able to get around this eviction bar after October 5th, 2020, if the tenant was guilty of unlawful detainer or your grounds to evict them accrued before March 1st, 2020. Also, too, there's a carve out for any notices demanding COVID-19 rental debt. And we're going to cover these Code of Civil Procedure sections in greater detail. So if you issue a new termination notice based on the new AB 3088 package, the court will be able to proceed forward on the eviction. Maybe. We'll cover that in bigger detail, too. If you're evicting a tenant for cause under Civil Code 1946.2, for the viewers of my other videos that talked about the AB 1482 package, everyone knows that basically for multifamily property, you cannot terminate a tenant's rental agreement without just cause. And that is enumerated in 1946.2. So the court can proceed on those types of cases as well, too. That's basically subparagraph 3. That covers basically all those type of evictions as well, too. So what does this mean for me, Rob? I might have issued a termination notice, a 60-day notice back in April of 2020, for example. Well, I think the bad news is, unfortunately for all these folks, is that my reading of 1179.03.5 appears to be targeting no-fault termination notices, i.e. your 30, 60, 90-day notices issued between March 1st, 2020 and present, and then tenants holding over on expired leases and our tenancies at will. For all those that don't know what a tenancy at will is, it's basically you don't have a paying rental relationship with your occupant. It's basically, think of a guest that has overstayed their welcome on your couch. That is a tenant at will, basically, under Civil Code 789. That's a long story short. We'll get a video explaining that more in detail here. Why am I saying that? Well, because 1179.03.5 is only allowing for fault or no fault terminations for tenancies under 1942 without any type of exemptions. So for those that kind of know about the AB 1482 exemptions, primarily the single family home exemption, you were excluded out of the AB 1482 package if you complied with several disclosures given to your tenant. Well, this new code section doesn't have any exemptions. The court is just stuck with, hey, I can't enter a unlawful detainer judgment till after February 1st, 2021, unless I have an enumerated statute or enumerated reason why I can enter an eviction judgment. So that's the bad news, basically. And the disclosure that I'm referring to is in this, it's like size 9 font. You basically had to give this disclosure to your tenant, and it has to be a part of your rental agreement as of July 1st, 2020. So to have that protection under under 1946.2, you have to give this disclosure to your tenant. I know there's going to be a lot of questions on that. We're going to make a separate video for that as well, too, because that actually, if your tenant refuses to sign an addendum to the rental agreement, having this disclosure, that could actually be just cause to evict them for failing to sign a lease agreement or a rental agreement on the same terms and conditions. But that's a different topic for a different day here. Okay, so basically, what I was going to say is there's another new section, CCP 1179.04. This is a disclosure that landlords must provide to their tenants if they had rent that accrued between March 1st, 2020 through August 31st, 2020, and as of September 1st, if that rent is still due to the landlord, they must provide this disclosure to their tenant by September 30th, 2020. It's a written disclosure that must be given to all tenants and occupants, and you basically it has to be in writing, and we have the verbatim language for it. It's pretty long, so I couldn't fit it in the slide, so we'll have it with the supplemental materials. In a nutshell, it basically tells the tenants, hey, we passed this COVID-19 Tenant Relief Act type deal. Here are all your rights about it, and here's how you can learn more about it. That's basically what it is. But you have to provide the disclosure in verbatim as it's stated in the Code of Civil Procedure. Okay. How does this have to be served? Well, for any of y'all that have done an eviction or have served notices to tenants, you can personally give this disclosure to your tenants personally. You can give it to another occupant in the premises. We call that substitute service, and then mail a copy by first class mail. You can also post and mail the notice as well, and just like you would with an eviction notice. It also says you can provide it by U.S. mail. And at the very least, if it was me, I would probably mail one certified mail, and then I'll mail one first class mail with a certificate of mailing showing that, hey, you put these items in the mail for them. At the very least, you have proof that you mailed it out on a certain date. And then the certification of mail is kind of there for, hey, your tenants, have to sign for a certified piece of mail, and at least you got a signature card. But if you can, by all means, if you can give this in person to your tenants and have them acknowledge the disclosure, that's probably the best thing to do here. The reason why you have to give this disclosure for any rent that's accrued between March 1st, 2020 and August 31st, 2020 is a landlord that fails to give this disclosure cannot collect on any type of you can't do any type of eviction under 1179.03 for this unpaid rent until at least after January 31st, 2021. The law basically penalizes you for failing to give this disclosure. And a side note is the code basically says that this disclosure can be made concurrently with any 15-day notice to pay rent under 1179.03. And you can see that in 1179.04 C2. We'll get into the details of 1179.03. That was kind of a difficult statute to read, but once you figure out what everything is going on, it kind of makes sense. So this is just saying the text for the full disclosure will be with the materials here. I can't fit it on this PowerPoint slide. It will be like in size 2 font, so we'll attach it with these materials here. Okay, so the new 1179.03, aka your 3-day notice, became a 15-day notice to pay rent with other disclosure requirements. And the deal is for any rent that's became due between March 1st, 2020 and January 31st, 2021, the landlord has to comply strictly with the Tenant Protection Act, or else any eviction may be fatally defective, and that will subject you to delays by the court dismissing your eviction case. You might be on the hook for attorney's fees for the tenant being the prevailing party, and there may be other consequences that you just don't want to face for not complying. Okay, here. There are two sets of requirements under 1179.03 based on when the rent accrued. Now, for rent that accrued between March 1st, 2020 and August 31st, 2020, landlords must comply with the 1179.03 requirements. And then for rent that accrues between September 1st, 2020 and January 31st, 2021, landlords must follow 1179.03C. So here's the deal here. What does 1179.03B require, basically? Well, the biggest changes are your 3-day notice became a 15-day notice, excluding weekends and holidays. The notice shall set forth the amount of rent demanded and the date each amount became due. Okay, this is a big difference from the original 1161 subdivision 2, because back in the day, you could just basically demand a chunk of rent. Let's say the tenant owed 6 months worth of rent, and it was the rent's $1,000 each. So you could, technically in an old 1161-2 notice, you could basically just say, hey, you owe me $6,000 without a breakdown in rent. Now, I don't recommend that you do that. It's better that you show how the rent accrued, so if it becomes an issue in court, you have those items spelled out so court understands how that accrued and so forth, and the tenant knows how it accrued. This is actually just codifying this practice here, so you have to be very specific. The tenant owed rent from September 1st to September 31st. The rent is due September 1st. It's $1,000. You have to spell it out here at this point. The notice has to advise the tenant that the tenant will not be evicted for failing to comply with the notice except as allowed by this chapter. If the tenant delivers a signed declaration of COVID-19 related financial distress, and the tenant must be provided a verbatim disclosure in 12-point font, and we'll cover that disclosure, that about their rights under the Tenants Protection Act, as well as be provided a blank declaration about the hardship, and we'll cover that more shortly. So, what ways must be disclosed to the tenant about delivering the COVID-19 declaration listed in 1179.3? Well, generally, the tenant can deliver this declaration to the landlord, particularly in the following ways: in person, by electronic transmission, if the landlord indicates an email address where the declaration may be delivered, through the U.S. mail, if the landlord doesn't provide an address where a tenant can physically deliver the declaration to the landlord. This is kind of follows the Code of Civil Procedure 1161-2 requirement. If you can't physically take rent to the landlord, the tenant, all they have to do is mail it and provide proof of mailing. Just get a certificate of mailing saying, hey, they dumped it in the mail. And if the tenant produces that proof that they mailed it, it's conclusively presumed that the landlord received it, even though sometimes in the U.S. mail, they can lose it. So it would behoove you to have some type of personal delivery, mechanism to get this declaration from the tenant. And through any of the same methods that the tenant can use to deliver the payment of rent pursuant to the notice, if the delivery of the declaration by that method is possible. So for your bank transfers, the tenant is not going to be able to deliver you a declaration at the bank when you make your deposit and so forth. Rob's my thoughts on this is make it as easy as possible for your tenant to deliver you this declaration. So if you don't get the declaration, you can go to the court. Well, judge, I mean, they could have dropped it at my house. They could have dropped it at my place of business. They could have transmitted. They could have just emailed it to me. And we're not trying to make this hard here. I just need to get the declaration back. Because if a judge sees that you're doing funny business with trying to deliver the declaration by eliminating the tenant's access and so forth, we'll cover at the end of the video, court may be able to excuse a tenant from strict compliance with this statute. So it doesn't behoove the landlord to kind of hide the ball in this situation here. Okay. Here's the new 15-day notice disclaimer you have to give to your tenants under an 1179.3b notice here. It's just verbatim, hey, you can be excused from not being evicted and so forth. Please fill out the declaration if you're having issues and you still owe the money to the landlord, but you can't be evicted for it. And for more information, go see the website that the state of California created. Okay. Let's see here. I'm trying to think. Okay. So it is somewhat different for an 1179.3c notice, but it is the same type of language. The same requirements listed out here, like under 1179.3b, is the same. We'll talk about high income tenants shortly because they have a little bit different requirement. You also have to provide them a disclosure as well to declaring that you have documentation that they're high income, and we're going to get to that shortly. This is what's really confusing about this statute here. Here's the big disclaimer that you have to use for 1179.3 notices, and this is again for rent that is accrued between September 1st, 2020 and January 31st, 2021. Okay. So, let's talk about the disclosure. It is a disclosure that is prescribed under 1179.02. And basically, all that needs to be provided is a sheet of paper basically saying the following: have a place for your tenant to sign under penalty of perjury and date. And just note that the tenant or anyone in their household that is a legal occupant can provide this disclosure with to the landlord, and they can they have to do this within the 15-day notice period to stop the eviction clock from running. Okay. So what happens if the tenant gives you back this declaration? Okay. There's two results. It's one under for rent that's accrued between March 1st through August 31st under 1179.3b. It basically says that tenant gives you back the declaration, then they're not in default with regards to their rent. In English, that basically means you can't evict your tenant for rent that is due under this 1179.3 notice. It appears to me that the tenant, you just lose your right to evict the tenant based on any rent that's accrued during that time if you get a properly executed declaration. Now, again, statute refers to, hey, the rent's still due, but you're going to have to go to another civil action or another, case. Like, you're going to have to file in small claims court to get your rent, or you're going to have to sue, in superior court to get that rent, depending on the amount of rent that is due. Okay. Okay, let's talk about the high-income tenants that send you a hardship declaration. The high-income tenant was kind of confusing to me how they used it, but the first thing you need to know is what is a high-income tenant and what steps do you have to do to demand rent for a high income tenant. So let's talk about what is a high income tenant under 1179. Basically, it basically says that a high income tenant means a tenant with an annual household income of 130% of the median income as published by the Department of Housing and Community Development in the official state income limits for 2020 for the county in which the residential property is located. Okay, in other words, guys, if you were with me with AB 1482, where we had to compute the CPI index, you're going to have to go to another state website and look up the median income per the Department of Housing and Community Development for the county in which your property is in. And for purposes of this, because it's based on household size, all lawful occupants, including minor children, count towards that number. So generally with how these charts work is, hey, the median income may be like $20,000 for a single person, and then it goes up to like $25,000 for two people, $30,000, and so forth. That's how that usually works here. So you have to go to this index and check out and see if your tenant's income is above 130%. But you know, a high income tenant in subsection C basically is not a tenant with a household income of less than $100,000. Okay, so what that means is, hey, your tenant's income may be 130% above the median income as published on the state's website, but if it doesn't equal or is greater than $100,000, then you're not a high income tenant. That's what that basically means. So what do landlords have to do for high income tenant termination notices under 1179.3 B and C? Well, again, like we said before, step one would be determining if your tenant is a high income tenant that either makes $100,000 or over $100,000 and has an income over 130% above the median income. If that is the case, then you need to, in your 15-day notice, disclose to your tenant this verbatim disclosure below. And my side note is, it appears to me that you must have to have this documentation on file. The landlord has to have it in like their rental application or inside their rental process per 1179.03D, because it only requires the tenant to provide verification if the landlord took documentation of the tenant's income. In other words, the landlords that don't do any tenant screening or have an application process where you document what the tenant's income is, I think you're out of luck. And the other subsections of AB 3088 kind of confirm that. So fortunately, if you don't have documentation of your tenant's income, you're not going to be able to show that they're a high income tenant based on what I am looking at right here. Okay, so if landlords comply with these requirements under CCP 1179.03, requiring a tenant to submit the landlord, in addition to the declaration mentioned, the tenant also has to provide documentation of their hardship, basically. So the tenant, a high income tenant, basically cannot rely on the declaration alone in itself that we just talked about. They're going to have to talk about provide some form of documentation, which is basically listed in 1179.03, basically. So what does that mean, basically, that the tenant can use? If you look at subparagraphs A through G inclusive, basically it's a tax return, a W-2, some type of written statement from a tenant's employer that specifies the tenant's income, pay stubs, documentation showing regular distributions from a trust, annuity, 401k, or other financial instrument, documentation of court order payments, including but not limited to spousal support, child support. Let's say you have a court order, settlement or something like that, and there's an order. You just provide that. Documentation from many government agencies showing receipt of public assistance benefits, including but not limited to Social Security, unemployment insurance, disability insurance, or paid family leave. Let's say military benefits, pensions and so forth like that. That can be used. Tenants may also use a letter from an employer or their unemployment insurance record as well, too. So if they're getting, unemployment benefits, that type of deal, or the employer writes, hey, listen, tenant so-and-so, his income was this, but now it's this. Yeah, that's probably going to qualify at this point. Okay. So the deal is, if a high-income tenant provides a declaration plus the documentation we talked about earlier in the earlier slide to the landlord, the tenant gets eviction protections. High-income tenants that don't comply with these requirements don't get the eviction protections, and that's per 1179.03. Now, here's the deal. I want to tell my landlords out there, no funny business, because here's the deal. A landlord that declares that their tenant is a high-income tenant, they have to plead that in their eviction case. So if you come to my office, we're going to have to plead we complied with all the requirements under 1179.03 and everything else that's mentioned in AB 3088 to do that. Now, if the tenant contests our findings that they're a high-income tenant, they get to rebut that at trial, basically, and they get to submit evidence showing that, well, Rob, that my income was high. It was above all the requirements, 130% of the median income. And yes, I was making over $100,000. But I just got laid off, during the eviction proceedings, or, right when I got the 15-day notice. And my employer told me, I can only have you come on 25% of the hours that you're receiving. Well, you get to rebut that in court. So, you don't want to make any funny business with that. And also, too, if the landlord had no basis or proof of income establishing that the tenant was a high-income tenant, the court can award or is required to award attorney's fees to the prevailing tenant. So if you guys have to litigate that, and landlord, you never had the documentation on file, you're going to be paying your tenant's attorney's fees for that. So that's why I'm saying no funny business on this high income tenant stuff. If you don't have the documentation, don't do it. Do not say that the tenant is a high income tenant. You do not want to be owing the tenant several thousands of dollars for defending themselves in an eviction proceeding. Okay. So we're going to review 1179.03C cases. Kind of did mention that before, and I think we might have some duplicate sides in here, but I'm sorry for that. We covered that earlier, but it's the same requirements though as 1179.03B. Basically, same deal. 15-day notice. The notice has to be particular with the rent demanded. And also has to advise the tenant that they can't be evicted if they provide the COVID-19 declaration. And you got to have the verbatim 12-point font disclaimer that we covered early, that was covered, and also the high income tenant disclosure as well. This is just reiteration of the declaration. Same one as in 1161 or 1179.3b. Okay. So what happens if the tenant basically complies with giving you the declaration within the 15 days, and if they're high income tenant, they provide you the documentation that they're covered? Okay. Law says basically no eviction before February 1st, 2020. The tenant cannot be guilty of unlawful detainer now or in the future. That basically means that, hey, everything is good. No, you can't evict the tenant based on this debt. If they pay an amount equal or greater than 25% of whatever rent was demanded. So basically this means so long as a tenant pays 25% of the rent that was demanded or that is due, you can't evict them, basically. Now, if they don't pay up to 25% of that income, you could evict them starting October 5th, 2020. And again, you can go after the tenant for rent that is due during this time in another court, basically. But they basically pay a quarter of what was demanded. And one or more notices that you give them, they're good to stay. Basically, that's what it looks like to me here. Okay. Tenants can stop or delay an eviction with a late filed COVID-19 declaration that we talked about in the 15-day notices here. So basically, what the law is saying, and the first 3 points are actually the text of the statute here. It basically allows a tenant to, in an answer or their response of pleading to your complaint, they can file this declaration here. They get a second chance at doing this. But the court is required to hold a hearing within 10 days to see whether or not the tenant had a justifiable excuse for delay in getting you this eviction. The code section is tying into another Code of Civil Procedure section, 473 subdivision B, which is for you that have ever done an eviction before and a tenant's filed a motion to set aside a judgment or to stay in eviction. They will use that same code section, and it basically says, hey, a judge can excuse a tenant's non-performance, basically, based on the result of mistake, inadvertence, surprise, or excusable neglect. A classic example of that is, hey, when you gave the 15-day notice to your tenant, the tenant was in the hospital, for COVID-19, for example. It doesn't have to be for that. Or they're having some type of surgery that they were gone for several weeks. And lo and behold, when they get back, they find out that there's been like an eviction summons and complaint and stuff issued. Well, tenant would have a really good excuse to say, hey, I wasn't there and no one was there, no one got me my mail, etc. That would be a good excuse. And I think the long story short of it is courts are probably going to be pretty liberal with letting the tenant slide. I would, some may not, but I would just presume that, hey, court's going to give the tenant the benefit of the doubt on it. Long story short of it is, for the landlord, it's going to at least delay the eviction process for you slightly. Very worst case scenario is if the court does accept the tenant's response, the case is probably going to be dismissed, and we're going to cover that shortly here. So basically, let's say the court agrees with the tenant's excuse. They didn't file their declaration on time, but now the court's going to accept it. Well, if it says here under 1179(3)(2), if it's before February 1st, 2021, and if it's based on a notice that has rent that was owed between September 1st and January 31st, the court has to dismiss the eviction case. Now, if it's after February 1st, 2021, the court can require that the tenant pay the rent within 5 days, excluding weekends and and judicial holidays, to dismiss the case. And a little bit of side note for the landlord: if the court dismisses the case pursuant to this subdivision here, the tenant is not the prevailing party. That is very important, because generally speaking, if you dismiss the case in favor of the tenant, they're generally the prevailing party, and that would trigger any type of attorney's fees provision, making you repay the tenant's attorney's fees. Well, that doesn't apply in this case if the case is dismissed based on this last chance type of hearing for the tenant to file their hardship, basically here. And that was this last paragraph here, I was thinking for a minute that this might actually comply. This actually might allow us to do evictions under the Solano County ordinance, but rereading the emergency ordinance again, it appears that it's just a straight up eviction ban during the COVID-19 emergency. I'm going to cover that in this last slide here. So the AB 3088 package basically precludes cities and counties from creating their own ordinances from taking effect during August 19, 2020 through January 31st, 2021. Now, they can create any type of regulations that they want, for COVID-19 debt. It just has to take effect after February 1st, 2021, basically. To review the Solano Emergency Resolution 2020-67 order, it basically states that the order is effective for 90 days after the state of emergency is over. For all of you that didn't see my last video, Solano's emergency resolution basically prohibits evictions for any rent that's accrued during the COVID-19 emergency. And they define the state of emergency from basically when Governor Gavin Newsom gave the county's authority to pass any type of emergency regulations. And that order, basically the extension of it, expires September 30th, 2020. Now, the emergency resolution says basically it's 90 days after the state of emergency is over. So one could argue that basically if Newsom's order N70-20 expires September 30th, 2020, it runs 90 days from that September 30th date, basically. Others could argue that the state of emergency is over when the COVID-19 state of emergency is lifted. It's kind of unclear, but I kind of side with the first understanding that it's going to sunset 90 days after September 30th, 2020, because that's where the authority that gave the Solano County Board of Supervisors authority to pass this type of emergency regulation. Hence, long story short, in a nutshell, all that is just saying we're still under an eviction bar at least through December 30th, 2020, based on Solano County's own ordinance here. I do not think we're going to be able to move forward with that. Now, I'm going to have to talk with some more smarter people than me to figure out if that's the understanding, because there is the issue of, yes, we do have AB 3088 in play as well. Does that preempt, or in layman's terms, does the AB 38 package supersede or take precedent over Solano County's ordinance? I'm not 100% sure on it, but I'm signing on the air of caution that our local ordinance is still in effect, because the county generally can regulate how and when you can do an eviction, and all the ordinance is doing is regulating an eviction. It's not regulating how or when tenants have to pay back the money. It creates some presumptions about a reasonable payment plan, but it doesn't necessarily regulate when a tenant actually has to pay the rent, basically. And I did have some issues with Solano County's ordinance, particularly make you fill in a disclosure that says in 12-point font, hey, you can't be evicted for, rent that's accrued during the COVID state of emergency. But it appears that the requirements under 1179.03 would preempt that disclosure based on this text right here, the notwithstanding text any other law. Notwithstanding any other law, if you comply with the 1179.03, that should preempt, that should supersede Solano County's requirement of putting in the, hey, you can't be evicted for any rent that's accrued during COVID-19. So I think that's it is kind of confusing, and because there are a lot of issues in play right now with state CDC's orders, AB 3088, local and county ordinances as well too. Here's the deal. Stay tuned to us for any video updates. We're going to have to create some more videos, particularly how the Solano County ordinance is going to apply with the new AB 3088. I still want to get some clarification on it. Granted that this statute, this bill package basically came out a week ago. I'm trying to understand it. I don't expect you all to understand every nuance of it right now. It just came out. There are other resources out there. I know CAA and CAR, California Apartment Association and California Association of Realtors have come out with materials and so forth, explaining these items. I need to talk to some practitioners myself about what they think everything looks like. That's kind of my understanding of this in a nutshell. So please, I guess my only word of advice is, if you do have a non-payment of rent situation, please, you need to have a lawyer look at this. I'm sorry, they made these evictions. They used to be really simple and straightforward. When I started practicing, they were treated basically like small claims cases, little petty traffic tickets. Now it's full-on litigation on every case. You have to expect that every case is going to be contested, going to be issues. I recommend that you get a lawyer of your choosing, dealing with this. And we're always here to help you out with this stuff too. So please feel free to contact us out. Again, we will be updating this material as more information and more better understanding of the regulations come out. So I thank you for watching up to this point, and I hope this helps out. We'll talk to you soon. Take care.